I mean, we called this 2 weeks ago, and we said she wasn't going to deny the motion. She wasn't going to deny anything, that this trial was going to go on. Check the previous video. But let's get into the motion denial.
State of Georgia versus DeMonte Kendrick. Order denying defendant Kendrick's motion for mistrial and supplement to same. Before the court is defendant Kendrick's July 23, 2024 motion for mistrial, supplemented on July 31, 2024. The court has also considered the state's response or argument by the parties, the transcripts of the June 7th and June 10th, 2024 ex parte proceedings, and the applicable law. The motion for mistrial asserts 3 grounds for mistrial, with the supplement asserting a related 4th ground. 1. That it is impossible to redo the proceedings that occurred on June 12, 13, 14, and 17 before the jury. In the interim between defendant's June 12, 2024 motion to recuse the predecessor trial judge and his ultimate recusal. 2. That defendant's constitutional right to be present at a critical stage of the proceedings was denied when neither he nor his counsel were present for the June 10, 2024 in chambers on the record ex parte discussions amongst the court. Prosecutors Love and Hilton, counsel for witness Copeland, and witness Copeland himself. 3. That defendant's due process rights were violated when the predecessor trial judge allegedly aligned himself with the prosecution team by his comments during the June 7, 2024 in court on the record ex parte discussion between the court and prosecutors Love and Hilton, and allegedly coerced witness Copeland into testifying during his June 10th ex parte meeting. And 4th, as raised in the defendant's supplement, that bias of the predecessor judge constitutes due process violations of defendant's rights under the constitutions of the United States and the state of Georgia. Kendrick also asserts that the motion for mistrial was goaded by the state when it requested that predecessor judge hold the June 10, 2024 ex parte meeting, which has been the subject of much discussion in the case. Absent Kendrick from that meeting and joined with the predecessor judge in the coercion of witness Kenneth Copeland. Impossibility of addressing or redoing the proceedings post June 12, 2024, which are void. Defendant Kendrick raises issues that the court has already addressed in granting defendant Williams' motion to invalidate and strike all proceedings that occurred in the above referenced case on and after the initial motion to recuse Judge Glanville was filed on June 12, 2024, as noted in the order granting defendant Williams' motion. The court has been working with parties on which testimony and evidence should be resubmitted, represented to the jury in this case, and whether any other the evidence at issue will be stipulated to as well as any needed rulings and/or instructions related to same. As such, the court does not find that there is an impossibility to address these issues, and therefore there is not a bias to grant defendant Kendrick's motion for mistrial on these grounds. The June 10, 2024 ex parte meeting. On June 10, 2024, at the behest of prosecutor Love, the predecessor judge held an on-the-record in-chambers meeting with Love and standing counsel for Copeland, Caleb Bumpus. June 10, 2024, transcript of ex parte, page 3 through 22. Following a recess at which time Love departed the meeting, Copeland and prosecutor Hilton joined the meeting. Defendant's motion raises several challenges to this ex parte meeting. Did defendant have a right to be present, and did the ex parte meeting amount to coercion of Copeland's testimony? And did the predecessor judge's comments and participation in the ex parte meeting rise to the level of due process violations? The ex parte meeting was at a critical stage and violated Kendrick's rights. Defendant argues that the June 10, 2024 ex parte meeting was at a critical stage and violated his rights since he was not permitted to be present. A critical stage is one which a defendant's rights may be lost, defense waived, privileges claimed or waived, or one in which the outcome of the case substantially affected in some other way. Brennan v. State. Defendant is correct that this meeting was about more than just parameters of Copeland's immunity and whether he understood its potential ramifications. That literally, you just agreed. Whatever. The initial stage of the meeting before the first break centered on the prosecution's concern with whether Copeland's main counsel was laboring under a conflict of interest and with the logistics of handling Copeland's testimony with standing counsel. But because these topics were all ancillary to Copeland's immunity grant, the topic of the meeting remained at its core, and as asserted by the prosecution, Copeland's immunity grant. Because the meeting dealt with Copeland's immunity grant and its ancillary issues, it was not a critical state of the trial at which the defendant had a right to be present. See Snyder v. Common of Massachusetts, criminal defendant has a right to be present when his presence has a relation reasonably substantial to the fullness of his opportunity to defend himself against the charge, but not when his presence would the presence of a defendant is a condition of due process to the extent that a fair and just hearing would be thwarted by his absence, and to that extent only. The fact that here discussions included what testimony would subject the witness to a charge of perjury that would subject him to punishment for contempt of the order compelling his testimony, and what that sanction might entail, even if incorrect, does not change the analysis. Defendant's rights were still not the subject matter under consideration. See State v. Laurie, no right to be present at hearing and compel witness testimony pursuant to immunity grant. Ex parte meeting at trials courts, behest between court, prosecutor, and counsel for witness initiated after defendant and his attorney had left the courtroom during a recess at the close of the witness direct examination, and held to ensure witness understood his deal with the prosecution and he was not knowingly incriminating himself and understood his constitutional rights, held to be an ancillary proceeding dealing only with the rights of the witness, at which defendant had no right to be present. The predecessor judge improperly coerced Copeland to testify. Separate from any defense right to be present for ancillary proceedings concerning witness immunity, defendant has a right to a fair, free of coerced testimony. Defendant asserts that certain arguably inaccurate representations made by the prosecutors and the predecessor judge to Copeland about the law of derivative use immunity, the applicable statute of limitations relating to what crimes the defense does not specify, and the length of his possible incarceration for contempt coerced Copeland into testifying. Yeah, so that's coercion. What the hell? Under both federal and state constitutions, a criminal defendant has a right to be present during critical stages of his trial. Allen v. State. Defense counsel should have been afforded an opportunity to attend any hearing where a sworn witness in the critical stage of this trial is being coerced to testify. Webb v. Texas. This touchstone for evaluating claims of coercion by trial courts of a witness testimony. Archer v. State provides another example of a trial court overstepping its proper role of neutral arbiter and rendering involuntary witness determination whether to testify. Here, Copeland had the benefit of counsel. The predecessor judge did not, on the whole, use intimidating rhetoric, but rather sought to ensure that Copeland understood the nuances of the decision he had to make. And he explained that many of the decisions about what could happen to Copeland were not his to make, but were up to the prosecutors. Still, some of the information provided to Copeland may have been inaccurate. While it is likely that Copeland was not induced by any inadvertent or inaccuracy to testify, the cleaner approach is simply to permit this issue, acknowledging past inaccuracies and advise Copeland anew. This is the course that the court has proposed, and the parties have affirmed its efficiency. Bias on the part of the predecessor judge constitutes due process violations. Based on the comments in the ex parte transcript made by the predecessor judge about counsel, both for the defendants and witness Copeland as well as outside agitators, defendant asserts that the predecessor judge during this conference revealed his partiality to the state, permitting the questionable accurateness of such characterizations and/or discussions. This issue has been mooted by the recusal of that judge from the case, wherefore all the foregoing reasons defendant Kendrick motion for mistrial and supplement to same are hereby denied. So ordered this 8th day of August 2024, Judge Paige Reese Whitaker, Superior Court of Fulton County.
Essentially, what she's saying is that y'all messed up. That's how I take that. That's how I really take that. At first, I ain't gonna lie. I was like, man, that judge full of shit. She ain't nothing, bro. She trash. She terrible. It's judges versus lawyers, blah, 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 and all that crap. And then I stepped back and took my emotions out of it. And so what I would like people to consider, right? If you say, hey, this judge over here is doing bad and doing bad and doing bad and doing bad, we need to go ahead and fix all of this crap, and you do it, you then are not going to get the benefit of saying, essentially, that nothing was done and we still need to end this, because something was done. That's the part where I believe the defense overplayed their hand. Some people are not going to like this, but I believe the judge is right. Yeah, some people are like, you already said the judges is right. Yeah, I get it, but please hear me out before you throw stones at me. If I tell you this is the bad egg and we got to get rid of the smell, and I get rid of the bad egg and the smell, and then you turn around and say, well, you know what, bro? Since the egg was already there, we got to get rid of the whole carton. I'm going to say, well, we got rid of the bad egg and smell. And that's essentially what happened. So they overplayed it, because if Woody would have stayed, if Glanville would have stayed and they could have went the other routes and stuff like that, which technically they couldn't, they had to go for recusal, then that would have been that. But what's even more interesting is they're not revealing how they got that information. An insider on insider, how they got the information was not from Caleb Bumpus, was not from Attorney Melnick, but was from a cop named Brown, who got demoted so bad, he's now doing juvenile hall duty now. He's no longer in the Fulton County Court. So all the speculations and stuff like that, we were all wrong, myself included. I thought Melnick sat up there and basically fired it off and all that stuff and everything like that, and they got rid of that cop. See, the cop Brown, if they were able to get him to testify, he would have destroyed everything, and then they would have been granted a mistrial. So in that instance, bruh, it is bad, because that's who told Steele. But also at the same time, there was another Brady violation, or was it? And I had to dispel a theory real quick just so people know.
I don't know specifically what was said.
So do you have any reason to believe Brady material or impeachment material was shared then? Or you're just saying they had a meeting and so there may be Brady material that stemmed from it?
My understanding is that there may be Brady material
that stemmed from it, but you don't know what it was.
If I knew what the Brady material was,
okay,
then I wouldn't have an issue.
Well, since there, Mr. Sledge's attorney was present at the meeting, so if Mr. Shart has spoken with him, or if, I don't know where the idea that there was Brady material, there's no privilege, so Mr. Sledge's attorney is a ready source of everything discussed at the meeting.
All right, maybe Mr. Shart, would you be willing to share privately with somebody on the defense? Do you have the same issue with talking to Miss Love that Mr. Steele does?
I don't.
Okay. Would you have an issue with sharing with her maybe the source of your information? And if you do, that's fine. But
I prefer not to.
Okay. All right. She seems a little in the dark on what might be. I don't know.
Not the source. Just if he would, just the content. I don't know what he's talking about.
I don't think he does either. Apparently he got some tip that Sledge may have provided Brady material, and that's about all you know. Is that right?
If there is anything inconsistent with what Mr. Sledge has signed in his plea agreements or anything, or said before, that would be considered impeachment and
therefore Brady. Yes. So you have reason to believe that he may have said something at the coffee shop inconsistent with something he already said.
I'm asking.
Can you be more detailed with regard to which thing it might be inconsistent to, or you just don't know?
I don't know.
Okay.
And that's why I'm asking.
Okay.
So, let's understand something. Moontunk's lawyer did not give Shart that information because that would lift the Brady material if he disclosed it to him. If I met with Attorney Love and I told him, hey, my client did some stuff and all this stuff that is detrimental to the case, and then my lawyer turns around and says the same thing, the DA doesn't have to do that anymore because my lawyer already did it. It makes it no longer Brady. So there's that. But I know from we'll just say an unidentified source that, yeah, there were some things admitted to that definitely was Brady. And if Attorney Love did not disclose that information, here we go again. But at this point in time, bruh, everybody wants a mistrial. But if they get granted a mistrial because the jurors can't get Lil Woody's testimony out their head, it's not going to be with prejudice, and it's going to start all over more than likely. If it was going a little longer, and this would be years on years on years on years, then yeah. But bruh, I don't know. I have it on good authority from somebody from Lil Jeff, aka Young Thug's team. He ain't pleading his shit. When he said, take that shit to motherfucking trial, Young Thug meant that. I 100% know that that's what's going on with him. He ain't taking no plea deals and all that stuff. So everything I said about, man, just take a plea deal, think of your children, he thinking for the long term, the long run, the kids taken care of, they with family and all that stuff. F that. He taking it to trial. He want to beat it, and that's going to be that. I ain't even mad at it. Fight, young man, fight. Rumble, young man, rumble. Fly like a butterfly, sting like a bee. But Sharp 100% got information that was 100% correct. And Attorney Love, and from what I'm told, when that little nugget was dropped, it got real quiet. It got real weird. It got hand caught in the cookie jar. Now, it is what it is. Subscribe, turn on that bell, stay notified, share to keep your people aware. Hey, y'all see, I ain't asking for the likes, but if you want more people to comment on this stuff and everything like that, you see, I don't delete comments. So if you want these views to go up and all that stuff, go ahead and hit the like button. If you don't, you want to be selfish, I ain't tripping either. Y'all do y'all thing, man. The Visionaries is on top. But I do have a question to ask you guys. Do you believe that this trial is going to be over Monday? Because essentially, you can't unhear a bell that's unrung. Or if you want a better visualization, you can't put the toothpaste back in the tube once it's already squeezed out. So I personally believe that the jurors are going to say, yeah, we can go ahead and forget all this stuff because we've been gone for about 2 months. But I'm going to keep it authentic with you. What do you think? I'll be curious. And y'all see, I do try to write back in the comments. So, once again, share to keep your people aware, subscribe to the bell to notify, and I will catch you on the next one. Enjoy your Saturday.